One of the central idea in French Revolution of 1789 was right to equality, and it was pronounced and propounded by the French political philosopher Jean-Jacques Rousseau, Voltaire, and Metternich during the French Revolution. And this particular right got its primary importance even in constitutions of the world, and as we found under part 3 of the Indian Constitution as fundamental rights, Article 14 has its prime importance as it provides equality before the law and equal protection of the law. So now we'll exactly explain what exactly equality before the law means and what exactly equal protection of the law means. So as it is provided, the very words equality before the law means that all citizens should be subject to the same laws, same courts, and same procedure, and that there should be no discrimination on the grounds of wealth, status, or position. And the words equal protection of the law were interpreted to mean that every citizen should be accorded the same treatment in similar circumstances, both in the matter of privileges conferred and obligations imposed by the law. These words, however, did not mean that each enactment should have universal application. So, in regards to this, our Supreme Court in the early judgment in the 1950s in the very important leading case, State of Bombay versus Balsara, it maintained that the concept of equal protection of law did not deny the state the power of classifying persons for legitimate purposes because the state had to deal with different types of persons having or creating different types of problems. So, our Supreme Court made a classification, and that classification should, however, be reasonable and should fulfill two tests as it was announced by our Supreme Court. And the first test, it should not be arbitrary and be based upon some real and substantial reasons. And the second test, that the differentiation should have rational relationship to the object sought to be achieved by the law in question. So, in relation to that, the very concept of equality received its most important connotation from our Supreme Court. And in this particular important leading case, State of Bombay versus Balsara. And now we'll go to the very source of right to equality. So, as per the very source of right to equality, it lies in the American and the Irish constitutions. It may be mentioned that the preamble to the Indian constitution speaks of equality of status and equality of opportunity, and this article gives effect to that principle in the text of the Constitution. In this sense, the demand for equality is linked up with the history of freedom movement in India. Indians wanted the same rights and privileges that their British masters enjoyed in India, and the desire for civil rights was implicit in the formation of the Indian National Congress in 1885. The Commonwealth of India Bill in 1925 in clause 8 demanded equality before the law and provided especially that there was to be no disqualification or disability on the ground only of sex, along with provisions that all persons were to have equal rights to the use of roads, courts of justice, and all other places of business or resort dedicated to the public. So, also, the report drawn up by the Motilal Nehru Committee as chairman of the committee appointed to determine the principle of Constitution for India in 1928, which was appointed by the Indian National Congress, and the Karachi Resolution of March 1931 reiterated this right in the Resolution on Fundamental Rights and Economic and Social Change. So, Congress also established the Shapru Committee, and the Shapru report of 1945 incorporating the proposals of the Shapru Committee while laying emphasis on minorities did gave importance to the fundamental rights, and as the Constitution for the proposed provision as it was that what the Constitution demands and expects is perfect equality between one section of the community and another in the matter of political and civil rights, equality of liberty and security in the enjoyment of the freedom of religion, worship, and the pursuit of the ordinary applications of life. So, these are the different sources by which the very concept, that is equality, as it is developed, and consequently it got its real importance not only in the Constitution of India but in several constitutions of the world. So, at present, right to equality in the very form of equality before the law and equal protection of the law has its prime importance in our constitution. And in relating to that, we have to make a critical analysis of the very idea of equality as it was explained with all legal ingredients, which better explain the very scope and jurisdiction of equality before the law and equal protection of the law. So, in our upcoming video, we will make that critical analysis on the basis of those legal ingredients which were responsible for the very explanation or expansion of the very scope and jurisdiction of Article 14